Welcome, ladies and gentlemen, to this UKLFI webinar on UN resolutions and the International Court of Justice. I'm delighted to have with us Anne Herzberg, the legal advisor of NGO Monitor. NGO Monitor is a globally recognized research institute promoting democratic values and good governance, and working to ensure that decision makers and civil society operate in accordance with the principles of accountability, transparency, and universal human rights. Now, NGO Monitor publishes research and independent analysis about non-governmental organizations, their funders, and other stakeholders, primarily in the context of the Arab-Israeli conflict. Anne Herzberg is an alum of Oberlin College and Columbia Law School. Prior to joining NGO Monitor, she worked as an attorney in New York, and her areas of research include business and human rights, international human rights law, the laws of armed conflict, universal jurisdiction, and international fact-finding, of course, including NGOs and the UN. She's widely published on these subjects. I'd invite you all to enter your questions into the Q&A facility, and after a presentation from Anne, we'll be moving straight on to your questions. Now, UN resolutions have taken on a new order of importance at the International Criminal Court in relation to Israel. We have seen this in the approach both of prosecutor Fatou Bensouda and subsequently in the majority decision of Pre-Trial Chamber 1 in February this year. Now, I'm sure many in our audience will be aware that on the 3rd of March 2021, the prosecutor announced that the investigation into the so-called situation in Palestine would proceed. Now, this followed the 5th of February decision on jurisdiction by the Pre-Trial Chamber. UN resolutions and publications were cited by the prosecutor in her request on the question of jurisdiction in December 2019. And they were then relied upon by the majority in their February decision, even though they are legally speaking insignificant. And we've seen in particular that carefully selected General Assembly resolutions are cited as a shortcut or a means around the need to engage in proper legal analysis and present a case with a legal basis. And thank you ever so much for joining us. You contributed significant reasoning and research on the reliance of UN resolutions in the prosecutor's analysis as part of a joint amicus submission to the court on this matter. And your analysis was picked up substantially by the dissenting judge, Judge Kovacs, in his very detailed dissent. Could you begin by taking us through the significance of the court's new approach to UN resolutions in the context of that case?
Thank you so much, Natasha. It's great to be here, and absolutely. So I'm going to speak for about 20 minutes on the role of UN documentation at the ICC. And probably we should have named the talk documentation rather than resolutions, because UN resolutions were the primary material relied upon, but there were a lot of other materials also that I want to talk about. And I also want to focus on how this reliance might impact the fairness of the proceedings at the ICC in general, but also in particular in our case in the situation of Palestine, and what that might mean going forward should there actually be cases brought before the court. So before doing that, I just want to give a little bit of background about the relationship between the United Nations and the ICC. Now, the ICC is an independent institution, and it is not part of the UN. However, the two bodies are very closely related. So if you look at the Rome Statute, there are several provisions in the chapeau of the treaty that talk about the close relationship between the UN and the ICC. And in addition, in 2004, they entered into a relationship agreement whereby they delineated the ways in which the two bodies would work together. And mostly that related to reporting to the UN, and also in terms of sharing information and developing evidence at cases. I also want to talk about, explain what I mean by UN documentation. So UN documentation can take many forms, And all of these forms I'm going to talk about have been used in ICC proceedings. So these include resolutions by the Security Council, General Assembly, Human Rights Council, UNESCO, the World Health Organization, and other agencies. They could be reports. So really the primary industry at the United Nations is report writing. When you add it all up, there are hundreds and hundreds of reports issued each year by UN bodies. And these can be reports to the Human Rights Council again, the General Assembly, the Secretary General. Also, there are what is known as special rapporteurs, which fall under the auspices of the Human Rights Council. And these are experts that are appointed to either touch on a particular topic, such as counterterrorism, detention, freedom of religion, or they can also focus on a specific country or region. So there's one for Myanmar, Iran, the Palestinians. And then there are also what are known as treaty body reports. So there are approximately 10 human rights treaties. And the committees for these treaty bodies, which look at state compliance with the treaty periodically, as well as they put out reports commenting on how to interpret specific provisions of human rights treaties. And also they will sometimes issue decisions on individual complaints for alleged violations of the treaty. So this is another form of report that the ICC has relied upon. And then of course we have what are known as fact-finding mission or commissions of inquiry reports. Again, these are primarily under the auspices of the Human Rights Council. However, there have been several and even a couple related to Israel under the auspices of the Secretary General. And there are UN agency reports. So agencies such as UNICEF, the UNDP, UN OCHA, they also put out many reports where they claim to be reporting on the facts or legal matters involving a particular country or region. And we have statements, of course, by UN officials. So you'll have the Secretary General might make statements, or the High Commissioner for Human Rights, or again, these special mandate holders, these special rapporteurs often frequently make public statements. Now, I just want to reiterate that although these materials are heavily relied upon by the courts, they are not binding law, with the exception of Security Council resolutions passed under Chapter 7 of the UN Charter. So if you're not talking about those specific types of Security Council resolutions, the rest of these materials are not binding law. They might be viewed as what is known as soft law, or they might provide indications of what the law might be. But again, they are not binding in and of themselves. And that will become important when we're talking specifically about the situation in Palestine. And this documentation has come into play really at every stage of ICC proceedings. So they've been relied upon by the Office of the Prosecutor at the preliminary examination stage, which just ended in our case in the situation in Palestine. Also now in the full investigation phase, they're relied upon, and that's going to be starting. It was opened in March, as Natasha mentioned. So we will see in our case how that's going to play out. They have factored heavily in confirming charges when the prosecutor has applied to obtain arrest warrants. And also they have been introduced as evidence during the trial, during various trials. Now, at this phase, they haven't all been accepted. Several defendants have actually challenged the admissibility of UN documentation. And in a couple cases, the court has knocked them out. But again, this just shows the various levels that these documents can come into play. So now in our case, in the situation of Palestine, these UN resolutions and reports and other documents, and the ones relied upon by both the prosecutor and the pretrial chamber are non-binding. They did not cite any Chapter 7 materials. They have played the determinative role in this case. And I don't think there are any other cases at the ICC where this has happened. So were it not for this UN documentation, we really wouldn't be even talking about an ICC investigation of Israel. So I'm going to talk about in 3 ways in which this documentation has impacted the situation in Palestine. So again, as Natasha mentioned, in December 2019, the prosecutor asked the pretrial chamber to confirm whether the ICC had jurisdiction over alleged international crimes committed in the West Bank, East Jerusalem, and in Gaza, such that she could move from the preliminary examination stage to the full examination stage. And the key question in her application was in determining jurisdiction, whether the Palestinian Authority constituted a state under the terms of the Rome Statute, such that when the Palestinians acceded to the Rome Statute in 2015, that doing so was valid. Now, before I get into the specifics, I just want to go back in time a little bit and talk history, because that's very germane to what we're going to be talking about now. In 2009, the Palestinians purported to join the ICC, and the prosecutor then, Luis Moreno Ocampo, did not issue an immediate ruling, which he should have, and said, you know, the PA is not a state, therefore they don't meet the requirements of the Rome Statute, which require states. The jurisdiction applies to states and state parties to the Rome Statute. And so he did not reject this application right away, but launched a 3-year examination of the issue. And in April 2012, issued a decision where he rejected the request to join the court. However, he did provide a blueprint to the Palestinians that they could use the United Nations to effectuate their accession. So he says, and I quote, "It is for the relevant bodies at the UN to make the legal determination whether Palestine qualifies as a state for the purpose of acceding to the Rome Statute." And essentially, the Palestinians followed this advice to the T. So first, they tried to join the Security Council, to get member state status at the UN, and they applied to the Security Council, but the Security Council rejected that application. So they next turned to the General Assembly, and in December 2012, the General Assembly passed Resolution 6719, essentially upgrading the status of the PA to a non-member observer state. Now, fast forward to December 2019 and the prosecutor's filing. The crux of the legal theory posited by the prosecutor was that the determinations for statehood for the purposes of joining the ICC could be made by the UN General Assembly, echoing what the previous prosecutor had said, rather than looking at how you define a state as commonly found in international law. So she said a UN determination could be the basis for that decision, not referring to principles of international law. And she also said that this was the case, that UN General Assembly resolutions were sufficient, even though, and I quote, "Palestine does not have full control over the occupied territory. The territory of Palestine appears to be in dispute, and the question of Palestine's statehood under international law does not appear to have been definitively resolved." So, nevertheless, she then proceeds to make an extraordinary statement, in my opinion, claiming that, nevertheless, this highly disputed notion of Palestinian statehood and what that territory would entail, that the court did have jurisdiction because it was entitled to rely, quote, "as a matter of fact, on the prevalent views of the international community." And the way that the court would judge the views of the international community was to look at UN General Assembly resolutions. Now, she provided no legal source to back up this claim about a legal determinative effect of views of the international community, or that UN General Assembly resolutions would be sufficient to evidence that view of the international community. So I think that's quite significant. And then she proceeded to say that because Resolution 6719 upgraded the PA to the status of UN non-member observer state, and using this moniker of state in that resolution, that was sufficient for the purposes of the Rome Statute, that the PA was a state and could join the Rome Statute, and therefore they could exercise jurisdiction. And essentially the pretrial chamber agreed with that. Now, one of the reasons and this was something I tried to convey in our amicus brief, was what was particularly shocking to me about what the prosecutor said was, in saying that UNGA resolutions evince the views of the international community, she completely discounted the process by which UN resolutions are created and passed, and in particular, the relationship between Israel and the UN. So the prosecutor's claims that the court could accept General Assembly resolutions as a matter of fact is simply not the case. Resolutions are the product, UNGA resolutions are the product of a manifestly political body. And this body exhibits long-standing institutional biases. And in relying on these statements, the prosecutor ignored these realities. And some of these realities include, since the 1960s, the General Assembly has been heavily dominated by three overlapping blocks of countries. Number one, the Organization for Islamic Cooperation, which is about 56 countries. The Non-Aligned Movement, which is more than 100 countries. And the Group of 77, which originally was 77 countries, but now has expanded to 135 developing countries. And so these blocks constitute an automatic majority at the UNGA, and they can essentially pass any vote they want. Now, so they represent really a segment of the international community, but they don't represent the overall views of the international community. And there's the old joke that many of you are probably familiar with from Abu Ebn, that if Algeria tabled a resolution that the earth was flat, you would have 120 votes in favor, 4 no votes, and 30 abstentions, referring to the European countries that always abstain from these votes. But that's the political reality there. In addition, a lot of the resolutions relied upon by the prosecutor were passed in the context of the Cold War. And again, the Soviet Union exercised considerable influence in driving the agenda of resolutions at that time at the UN, and also really disrupted or obstructed consensus positions within regional groups, and really kind of radicalized the language of a lot of UN resolutions at the time. So again, this was neglected by the prosecutor. Another point that was not mentioned was that UN resolutions in the context of the Middle East are the most heavily contentious votes at the GA. Now, normally, many resolutions are passed by consensus. Again, that doesn't mean it's reflective of a view of the international community, because there are other factors behind it. But in regards to the Middle East, these votes are always highly contentious for the most part. Also, a vote does not necessarily mean that the country voting for it actually agrees with the language of the resolution. So there may be many factors that have motivated its vote. So number one, it could be acquired through horse trading. You vote for my resolution, I'll vote for yours. Or you vote for my resolution, I'll give you aid or some other benefits for voting for my resolution. And often, particularly when dealing, let's say, with Resolution 6719, many of the countries voted for the resolution, but that did not mean that they thought there was a Palestinian state. They said in their statements on the vote that they were voting for it aspirationally in the hopes that there would be a Palestinian state in the future, or to support the peace process. So again, even though the prosecutor was using this as to stand in that there was this existing Palestinian state, most of the states that voted in favor did not agree with that sentiment. Some other points I would want to raise that don't necessarily relate to our case, but also relate to other cases, is just the concept of, majority views. And what about minority rights? So often, and this also ties in to Israel, because it doesn't have a majority of votes on, it's probably impossible for Israel really to get a majority on any vote, or very rare at the GA. Because of this voting system, the block system, it is there's a heavy focus on particular countries. So as we all know, or most of us probably are aware, there are more resolutions and reports issued on Israel than any other country at the UN, and most likely more than all the other countries combined. And so that can really skew the record. So you're going to have lots of materials, let's say, on Israel, but what if you're dealing with another situation, the Uyghurs, let's say in China, or a case, Georgia or something falling under the jurisdiction of the ICC, not the Uyghurs, but other situations, there's much less material to be relied upon. And you have a very skewed view of what's going on. So this can also prejudice minorities who can't get the support of states at the UN, and what about their cases and being able to get a case before the ICC. So I just want to throw that out there. And also, another particularly contentious issue, which maybe we'll talk about later, is the issue of, let's say, UNESCO designations. Again, this isn't limited to Israel. These also can be very highly contentious. So it's not just limited to UNGA votes. Now, again, with Israel, this is all very heightened because of how Israel is treated at the UN. And when we're talking also about the UN Human Rights Council, it's even more pronounced because, as again, most of you probably are aware, Israel is the only country with a permanent agenda item at the HRC. It's the special rapporteur for the Palestinians is the only mandate that is one-sided. So he is tasked only with looking at violations committed by Israel and not by Palestinians. And it's the only mandate that never expires. And until recently, up until really only a few years ago, Israel was blocked from joining regional groups at the UN. And that's a significant way in which you can influence the agenda of the votes or of the resolutions. And so Israel was not able to be a full member of the Western Europe and others group until very recently. Now, Judge Kovacs in his dissent, which I actually highly recommend everyone looking at, it's really a tour de force, just going over issues of international law, even aside from our specific issues on the UN resolutions. And it was a 154-page decision, as opposed to the majority opinion, which was, when you take out all of the summaries of the filings, was about 25 pages, just to show you the difference. So he really took issue with this reliance on UNGA resolutions. First, he voiced the objection that it was highly improper for the court to outsource its competence to make determinations on jurisdiction to the UN. So he really wanted to fight against that. The ICC is an independent body. It's not bound by the UN, and it should make its own decisions, not bound by what the UN does. So that was his first point of objection. And then he really took issue with this reliance by the prosecutor on Resolution 6719 in particular, but also that, in his words, no evaluation was allowed by the prosecutor or even deemed necessary by her. So it was just a fait accompli. You had this resolution and that was the end of the inquiry. And he again really took issue with that. How could you have all these presumptions and not go into any analysis, and kind of what I was talking about, like the context behind the votes, that you would just rely on those votes in and of themselves. One of the things that he focused on also was how the resolution was not indicative of views of the international community, that Palestine was a state. And one thing he did, which I found really interesting, was at the end of his opinion, he had this very extensive chart that laid out statements by the PA, UN officials, and in some of the resolutions, going over how none of them thought that Palestine was a state. And so I really encourage people to look at that, because that was quite fascinating. Because he wanted to highlight, that you can't rely on these resolutions necessarily as standing in for the legal proposition that the prosecutor was trying to advance. I mean, he didn't even get into this concept, which I think is really interesting, about views of the international community and how that even actually is a legal standard. And one notable example, when you look at the history of the state statements, when the resolution was passed, was that of Italy, because Italy said, we are voting for this to support the Palestinians, and only because they gave us assurances that they would not use this vote to go to the ICC. So, so much for those promises. But again, these were some of the considerations that the countries made that did vote for that resolution. Just another area where resolutions were posited to stand in lieu of actual legal analysis also went to the status of the territory as occupied. So again, the prosecutor cited to a host of resolutions talking about the territory being occupied, and therefore she didn't have to do any legal analysis. Was this an international armed conflict? Did the Geneva Conventions apply even? Who are the high contracting parties? Can we call this an occupation? She didn't do any of that. The resolution says occupied, therefore it's occupied, that's the end of the story. Another way in which the resolutions were relied upon was to determine factual matters, such as that the territorial scope of the court's jurisdiction was East Jerusalem, West Bank, and Gaza. And again, this was an area where Kovacs took a lot of issue with, because he was saying, when you look at these resolutions, they talk about defining the territory in the context of negotiations. They aren't specifically saying definitively that that is the territory of a Palestinian state. And also, another argument put forth by the prosecutor in the pretrial chamber was this concept of self-determination. And then that meant that because the Palestinians had a right to self-determination, UN resolutions talked about this right of self-determination, and also in that resolution talked about supposedly the Palestinian territories being Gaza, West Bank, and East Jerusalem. That somehow granted the Palestinians full legal title over this territory, such that the court could exercise jurisdiction there. So he also took issue with that. One notable thing was the pretrial chamber, for instance, refers for this proposition to Resolution 242, but Palestinians are not even actually mentioned in Resolution 242. The word Palestinian does not appear in that resolution. And that resolution actually talked about withdrawal from territories, not all of the territories. So again, not only was this kind of a strange analysis taking place, but some of the resolutions were misrepresented. Sorry about that. The third way in which this documentation was used was that, and in this instance, the prosecutor really looked at not so much resolutions, but at other types of UN documentation, such as fact-finding missions. She used that as evidence of was a reasonable basis to proceed because sorry,
There's an emergency at the UN that you're required
I
for.
think it's someone ringing my doorbell. Sorry about that. So she was relying on this other UN documentation that there were reasonable grounds that international crimes had been committed. And so reliance on this type of documentation is particularly troubling because when, again, like the resolutions, she ignored the context behind these fact-finding reports, and particularly those under the auspices of the Human Rights Council. So those types of fact-finding missions, such as the Goldstone report or the report on the 2014 war, had one-sided mandates. They were mandated only to look at Israeli violations. The appointment process is secret, so no one knows how the people were selected. And many of the people who were on those missions had made prejudicial comments about Israel prior to them joining the mission. And then also in terms of the methodology of these commissions of inquiry and fact-finding missions, that it is very hard for them to actually engage in verification of facts. And so often, really, the way these reports are put together is they are crafted mostly from NGOs, just cribbing together a bunch of NGO reports without actually checking to see that the facts alleged are true. And most of these commissions do not possess the requisite expertise, such as experts in laws of armed conflict or military operations, or experts of international criminal law. Another important point about these types of fact-finding missions is that they are put out for a particular purpose. They're not put together to serve as evidence in criminal cases. They're put together to raise awareness of a particular issue or to get publicity or for political purposes, and they're not meant to serve as in criminal proceedings. So that's also an important point. So I'll just want to, before ending, just sort of raise this issue of fairness of the proceedings. What does this all mean for the fairness of proceedings and particularly going forward? So I think it really does, even though the prosecutor has denied it, it does raise the specter of bias, because to rely, especially in the case of Israel, but it also applies to some degree in other cases. And like I said, it has been raised in a couple other cases before the court, that to rely on UN materials and not be conscious of or even acknowledge the highly contentious relationship between Israel and the UN is, I think, somewhat dishonest in my opinion. And a good example of this would be that in her filing to the court, the prosecutor relied on some of the most biased UN materials out there. For instance, she relied on a 1979 report purporting to tell the history of the Arab-Israeli conflict that was produced by the Committee on the Inalienable Rights of the Palestinian People. She had more than 60 citations to this anonymous report. And for those of you who don't know, the committee was established in conjunction with the infamous Zionism is Racism resolution. And the ADL has branded this committee as the most anti-Semitic body at the UN. So for her to rely upon that report from that committee to serve as the source for her historical narrative of the conflict is quite troubling in my opinion. Also, just a couple other issues, it also could be prejudicial once you get to the stage, if we get to the stage of individuals, arrest warrants being issued, or in the unlikely event there is an actual trial. It's very hard to overcome the credibility of the UN. And so it will be hard for a suspect to challenge the credibility of these reports. Another concern I have is that because a lot of these materials are being put in at the preliminary examination stage or in the investigatory phase, once you get to a case, these documents may really already be part of the court record. I know they start anew, but it's hard to get that out of the record. And so it could be hard for a defendant to challenge these materials. Also, a lot of the resolutions and documentation is quite old. Like I mentioned, this 79 report, or a lot of the resolutions date from the 70s. And so it could be very hard for a defendant to challenge the validity or the credibility of these reports when you're talking about something that happened decades ago. And back then, you didn't have the internet. It may not be, you may not have the ability to get all the information you need to challenge the credibility. So I think these are going to be ongoing issues. Also, just another issue I think is deemed in, looking at sort of the perspective, especially in our case. So if you're looking at UN reports, that's setting up a very particular historical narrative that favors the Palestinian narrative. And so therefore the prosecutor uses that in terms of crafting the potential crimes let's say crimes against humanity or something, inferring discriminatory intent for things. Whereas for an Israeli or Jewish perspective, certain acts might have been taken to protect Jewish heritage or protect against concerns of genocide. And so again, by use of these resolutions, that's also impacting the way the narrative shapes out in terms of how these cases go forward. So I just would close, giving the very high likelihood that these materials are going to be used significantly. It's really important for those of us who find this problematic to debunk language claims and methodologies in these reports in order to at least, even if they are not ultimately rejected by the prosecutor or the court, at least there's a record out there showing why it is improper in many of these cases to rely on these materials. So I will leave it there and open it up for questions.
Well, Anne, thank you very much indeed. I've noted the UKLFI team putting links to the majority decision, the dissent, and some of the key resolutions that were relied upon in the chat. So I'm very grateful for
Great.
that. I have seen a number of questions coming in, and we will get to as many as possible of them. Just before that, though, I did want to pick up on this UNESCO issue briefly, because in April you submitted a communication to the prosecutor of the ICC together with 9 Bedford Row,
Yes.
leading international criminal law set of chambers in London. And that addressed the court's draft policy on cultural heritage. It stressed the requirements of the Rome Statute and the principle of legality. And it also raised concern that the draft policy doesn't reflect ICC case law and may in fact assert propositions which are inconsistent both with the court's jurisprudence and customary international law. It's an area of danger, certainly, so far as reliance on UNESCO resolutions is concerned. Could you talk a little bit more about what might be specific to UNESCO and the dangers adhering to that?
Yes. So in March, the prosecutor put out this draft policy where basically she wants to highlight that cultural heritage is going to be an issue of extreme importance for the Office of the Prosecution going forward. And as we know in our situation, there could be a lot of landmines here. In particular, because we have contested areas of cultural heritage, notably the Temple Mount, the Old City, in the West Bank or Judea and Samaria, the Jewish historical sites, this could really end up being a problem. And when we look at, so in the past few years, there have been some extremely contentious UNESCO resolutions passed designating Jewish historical sites as Palestinian sites or as Muslim holy sites, while downplaying the Jewish historical connection, or also completely erasing Israeli ties and historical connection to these sites, notably Hebron and the Old City. And so, this is something where is if they are going to be relying, like they did about statehood and the territory, delineating the territory on UN resolutions, I have a lot of concern that they might rely on these UN designations, the UNESCO designations, to say, for instance, the Old City is Palestinian. It's not Israeli, it's not Jewish. And therefore, you're committing international crimes there. When if you have Jews living in the Old City, when you do archaeological digs in the Old City, when you establish, the Western Wall Plaza and try to make it nicer, are these going to be considered war crimes by the prosecutor? I think this is an area of extensive, extreme concern actually going forward.
Right. Well, coming back to the question of jurisdiction, I'm going to start with our questions from the audience. And the first I have is, if only a small number of states or members of the Rome Treaty in particular recognise Palestinian statehood, how can the prosecutor claim that she is basing her decision, or at least her approach, on jurisdiction on, quote, prevailing international opinion?
Yeah, I mean, it's a very good question. And in fact, Judge Kovacs, in his opinion, actually highlighted the number of countries that were member states to the Rome Statute, and whether or not they agreed Palestine was a state versus um, countries that oppose that versus countries that purportedly do recognize Palestine as a state. And he said, at best, it was even. And therefore, you could not say that this was reflective of views of the international community. So again, it's disturbing. And also I found disturbing, she didn't give a definition of what she even meant by views of the international community. Who is this community? What does that mean? Um, you know, what is it a simple majority? Does that then mean it's the view of the international community? What exactly is that? So again, that's something I think they need to be pressed on going forward in any proceedings.
Well, along the basis of the position as they've articulated it, we've had another question on if the state of Palestine is being recognised de facto by the ICC, can it be held responsible for its own war crimes, and is Hamas considered to be part of this state?
So, okay, so yes, the prosecutor can investigate them. She has indicated that she is going to be looking at Hamas and other Palestinian armed groups, notably for Gaza, rocket fire from Gaza. However, what I have found really notable, both in her filing to the courts and in the Q&A that the court put out after the decision in February, and also in her summary of the preliminary examination, she specifically excludes Palestinian authorities. Now, a lot of proponents of the court are going to say, of course, they could look at Palestinian authorities if they want to, they have the ability to. But why are they excluding them then from all of this documentation? Now, in 2019, she indicated she might be looking at the pay for slay concept, but that was dropped out from her filing to the courts. And I have serious concerns that they will not be investigating the Palestinian Authority. And which I think this plays in, at least in my mind, about why it is so political, because for the Palestinian Authority, it's a win-win. They get to go after Hamas, which is their political opponent, and they get to go after Israel and use the court to go after both of their opponents, and they get off the hook. So.
Well, out of interest, if the court were, for the sake of argument, to pursue an investigation into the pay for slay policy, where would that leave many European countries who have either unwittingly or perhaps in some circumstances wittingly been contributing substantially to and funding the payment of terror salaries through their own donations towards the Palestinian Authority? Is there any responsibility that one might trace back broader than even the Palestinian Authority, do you think?
Yeah, I mean, I think it's a possibility. I do think, you'd have to examine the elements of such a case, in terms of, aiding and abetting, liability, and that kind of thing. But I would be concerned, if I was a European official, because they would have jurisdiction over them. And if the court does take that up, that it is a possibility depending on how integrally involved they were in it.
Now, Anne, one of the issues addressed in the amicus submission that you've put forward as a whole is, of course, statehood and the criteria under the Montevideo Convention. And we've had a question here, does the Rome Statute require statehood based on Montevideo? So what is the connection between statehood for the purposes of the Rome Statute and more broadly customary international law and the requirements of that convention?
Well, I think prior to February, I would have said that Montevideo and other, metrics of determining statehood under international law would be how you would interpret the Rome Statute. In order, when they use the term state, that's how you would apply the term state. However, this this decision now has really changed that, and basically said that if you have some type of UN statement saying that an entity is a state, there's jurisdiction under the Rome Statute. So, that's quite interesting. And I don't think enough member states or in the Assembly of State Parties have really spoken out about that. I guess, whether they mind or not. There have been a few who've been vocal: Germany, Austria, Australia, for notably. Um, so that is quite interesting, I think, going forward. I don't think that was the intention, when the Rome Statute was drafted. It certainly was not the intention, that you could just label something a state without doing any sort of legal inquiry whether that was actually true. So
If I may, perhaps a point of clarification. We have had a question as to why you keep referring to Palestine. The questioner says, my understanding is that Palestine ceased to exist when the region was divided into Israel and Transjordan. So could we provide some clarification on the terminology here and how the court has approached naming the investigation that has now begun?
sure. So they call it Situation of Palestine. So that's why I've been using that. Generally, though, I personally refer to the Palestinian Authority because that is the quasi-governmental entity operating, or government, however you want to define it, operating in those territories. So that's generally what I say, Palestinian Authority, but the court is using the terminology of Palestine.
Very much on that basis, we're being asked, is the ICC's credibility now under threat? How is the rest of the international community reacting to the ICC's departure from these principles that it's supposed to uphold? What has your assessment of that been in recent weeks?
I mean, it's a challenge for the courts. Again, this isn't the only case where they've been having problems with their credibility. In end of September, well, it was more like a year ago, the Assembly of State Parties appointed an independent expert review mechanism to look at issues with the court. And they produced a very lengthy report with various problems at the court. And so they're already having issues with credibility, just in terms of the operations at the court, in terms of how long it's been taking them to do trials, how much money they're spending. Again, lack of experience on criminal investigations in the prosecutor's office, being very wide-ranging in case selectivity. So that's already an issue. And then we get to our case, which is the most contentious political case probably in the world today. I don't think it helps their credibility. I don't know. I don't know because, oftentimes, again, unless member states speak out against it, they're going to keep going with it. So, it's unclear. It's unclear, the long-term impact.
Sure. And following on from that, someone asks, will things change when the new prosecutor, Karim Khan, takes over? What what
Yeah,
what predictions might we be able to make on that?
right. At this point, I don't think we can make any predictions. So we'll just have to wait and see. I'm sure he will. I would assume when he takes over, he'll want to look at all of the cases anew, afresh, and start from the beginning, rather than just simply carrying on where she left off in all of her cases. But yeah, I have no idea how he's going to approach matters at the court, actually.
If I can take you back to the UN documentation that we were discussing, there's a questioner who asks whether the reports that you've been outlining are not in fact hearsay and so inadmissible, particularly in criminal proceedings. So, what is the basis upon which the ICC has taken these reports of NGOs, civil society organizations into account in terms of these criminal proceedings?
Yeah, I mean, it's a big question. I mean, particularly because they are hearsay mostly, if not exclusively. Um, when you look at, I don't really think the prosecutor has, I don't think it's been troubling her actually to do so at the preliminary stages and in the investigatory phase, and even really in the stage to confirm charges. Now, like I mentioned, it has come up in a couple cases, notably with the DRC, where she tried to enter into evidence a myriad of different UN documentation, and some of that was knocked out by the court on some of the bases that I had spoken about. So again, when you get to that phase, but those cases also were pretty old, more than 10 years ago. So I don't know going forward. It's the kind of thing, it's unknown. It's unknown. In any given trial chamber, we just don't know what their view is. But it's true, it is all hearsay, or in most cases.
And
there might be certain reports that aren't, but the ones I was talking about are hearsay.
And a question that goes to the use of intermediaries.
Mhm.
The use of intermediaries in criminal cases, this question says, is not enough to collect evidence. And it would seem that the ICC's decision so far is due to be based on intermediaries. So the question asks, how is this bound to affect the case going forward?
Yeah, so it has been an issue in DRC and Kenya, the intermediaries issue. Now I think it was the same in Kenya, but I'm not 100% sure, but definitely in the DRC case, there were allegations that they were basically paying these NGO intermediaries to what's the word, sort of liaison with witnesses. Now, they argued, that just was logistics. We were just helping them, get to the courts, or, we weren't coaching them on what to say. But again, it does raise that question. And in our case, I mean, the prosecutor, and she admits this freely in her preliminary examination reports, that she has been working with and relying on Palestinian NGOs almost exclusively for her materials. And she's published lots of pictures of herself with these NGO officials. So I do think that is something that certainly we're going to have to keep tabs on. How these groups are being used, for sure.
We've had a few much broader questions, one of which is, as things stand, and if Israel did in fact decide to participate, the questioner asks, would Israel have a good case to defend against the accusations? I appreciate that's probably a whole separate webinar, but do you have any initial thoughts, given the nature of the allegations that the court is investigating?
I do think we have a great case on all the allegations that potentially could be raised. Unfortunately, because we're dealing with this type of institution, I'm not sure it matters, unfortunately. I mean, we'll have to wait and see. Again, the likelihood of any Israeli coming before the court for trial is, I think, extremely remote. I honestly, I can't see it happening unless there's some very strange courses of events that take place that would happen. So it's highly unlikely. But when you look at when like actually in the flotilla case that got the Comoros case that did get dismissed, the prosecutor decided not to open a full investigation. But in talking about the law of the case, interestingly, Judge Kovacs had a very interesting dissent in that case also, because one of the decisions was that they wanted the prosecutor to go again and re-examine the facts to just make sure one more time that there wasn't sufficient basis to open an investigation. And he basically pointed to the fact that when they were describing the events at issue, they were using what I call and others call an effects-based analysis. And this is getting to the laws of armed conflict, where when you're looking at the impact of military attacks, and you're trying to assess whether there's been a war crime because you're looking at the civilian damage, whether you were targeting civilians or that the effect of the or that the attack was disproportionate. Oftentimes what NGOs do is they will do, or the UN fact-finding missions, they take an effects-based approach, which is wrong. So they look at how many people were killed or how much damage was done, and just looking at that metric, they determine it was an indiscriminate or disproportionate attack. But that's not how you determine whether or not there has been a war crime. You have to look at what information was available prior to the attack to a commander, and did that commander act reasonably on that basis? And so Judge Kovacs actually noted how problematic it was that in this Comoros decision, they were applying an effects-based test, which is not the legal standard. So again, I feel like it's all up in the air when it comes to these bodies that, even though the law is clear, they may not apply it clearly, which is not good from our perspective.
Well, and we are fast reaching the end of our time together, but perhaps I might ask a final question, which is perhaps more of a practical one. And that is, are there any signs the Western world, and this is specifically state parties, I should stress, would enforce any ICC arrest warrants should the court issue them? Do you have any thoughts on whether that might be followed through with?
Yeah, it's a very interesting question. Because a lot of the state parties, they, vis-a-vis their obligations to the court, they have to cooperate with the court. So this is going to put a lot of countries in a bind. Um, on the one hand, are you going to have a massive diplomatic incident should someone be arrested, and potentially also, have the wrath of the United States behind you, or are you going to cooperate with the court per your obligations in joining the court? Now, I don't know. I mean, presumably maybe people would be tipped off ahead of time, so it wouldn't get to that point. But it is an open question. Yeah.
Well, Anne, thank you so much for taking the time to go through this topic with us. I should perhaps also say that you're the author of the widely cited NGO lawfare, Exploitation of Courts in the Arab-Israeli Conflict, also co-author of Best Practices for Human Rights and Humanitarian NGO Fact-Finding, and co-author of the Goldstone Report Reconsidered, which was a critical analysis on that perhaps infamous report. And I believe that all of those publications are available on the NGO Monitor website, all through them. Tremendously grateful for you having taken the time with us this afternoon, and thank you to the audience also for incredibly thought-provoking questions. We tried to get through as many of them as possible, but this hour has truly flown by, so thank you very much indeed.
Thank you so much. It was fun.
Have a safe week ahead.